everybody, and thank you for joining us today for the next edition in our installment with Start a Brewery. Presents Show Me the Money, legal issues involved in raising funds for your brewery. Here in CBP, we're proud to provide resources from everyone from the brewery and planning to the industry veteran. And we're really proud and excited with this partnership with Laura and the team over at Start a Brewery. And Laura, I'd love to you share a little bit more about Start a Brewery for anyone who might not be in the know.
Of course. It's super awesome to be able to partner in this. And I think that it's nice to, just find the people in the industry that are really aligned to help raise the bar and bring knowledge across the board. We started Brewery focuses on education and lowering the barrier to entry. I think CBP aligns very well with bringing all of the education and resources and industry, professionals to the bar as well. So literally and figuratively both. So super happy to be here, super excited for Jeff to join us today. And I personally have a lot of gray zone in terms of raising investment capital in my own learning. So I'm really excited to really dig in and learn myself.
And Laura, for anyone looking to learn more about Start a Brewery, where can they do so?
Well, startabrewery.com is a great place to start, but we also have our podcast, and you can find that any place that you find your podcasts. Plus, you can also go to our event hub to find that. So lots of things. We also have resource groups once a month on Wednesdays where we have a contributor in the spotlight. Jeff and Andrew are both contributors, so you may see one of them in the spotlight. So it's, we have lots going on. So tune into our website to find out more, or, on the closest podcast to you. So thank you for that.
Well, thank you, Laura. And Jeff, we're going to now turn the floor over to you, and I'm excited to learn.
Thank you, Andrew, and welcome everybody, and thank you for tuning in. My name is Jeff O'Brien. I'm an attorney with a law firm called Chestnut Cambronne based in Minneapolis, Minnesota. I've been working with breweries, distilleries, wineries for the last 15 years, but at the heart, I'm a business lawyer, and I do a lot of private securities work, which is the topic we're going to talk about today. And I regularly advise businesses, including breweries, as to how to raise capital for a new venture or an emerging venture, which is one of the most difficult things I think there is to do in starting a business. Is just trying to find sources of capital to get the business going. And so I'm gonna a little show and tell to start out before we get into the meat of it. And I apologize in advance. It's going to be a little bit of legalese, but that's what securities law is all about. Is that you want to know? It's a little boring until you get into trouble, and then it's not. So you want to keep it boring. But I'm going to show a little show and tell. Hopefully you guys can see this. This is a movie called Bobby Jones' Stroke of Genius. It's from 2004, I believe. 2004. That was the very first securities project I ever worked on, was raising money for that film. Probably haven't heard of it. There's a reason for that. Didn't do very well, and investors didn't get their money back. But because we did everything compliant and disclosed everything and the risks, none of the issuers got, the issuer didn't get in trouble, because that's the nature of investing money in a small business or a venture like a film like that, or a brewery. So we're going to start with talking about what is a security, and gets a lot of confusion about this, and I have had a lot of confusion. I've had a lot of clients that come to me over the years that think that securities mean stocks, and if they're not selling stocks or equity, then they're not selling securities, and that's not true. Securities can be a lot of things, and there was a Supreme Court case called Hoey, and there's a test that was established as to what constitutes a security. And what it is it's an investment of money in a common enterprise with the expectation of profit, or to be derived from the efforts of others. That's a real broad definition. That's not just equity and equity ownership in a company. Any sort of promissory note that's convertible into equity, any sort, you talk about a thing called a SAFE, which is a simple agreement for future equity, and I'll talk about that a little bit later. Even an unsecured promissory note, to the extent that it relies upon the business, the borrower, succeeding in order to repay that note with interest, all of those things can constitute a security. And once you've determined that something is a security, now you have to worry about compliance with federal, and state securities laws. So why do we have securities laws? Well, because something happened in 1929 where a lot of people, where stock market crashed and a lot of people lost money. And there were people that I mean, they lost a lot of money, and it led, of course, to a depression in this country. And so, as part of that, when Franklin Delano Roosevelt became president, one of the pieces of the New Deal was to establish a Securities and Exchange Commission and introduce federal securities regulation. So there was some sort of guardrails and safety mechanisms to keep 1929 from happening again. So that's kind of the basis for why we have securities laws. So there's your history lesson for the day. So what are securities laws other than rewards or donation-based crowdfunding? Like I said before, almost all means by which a company raises capital online will involve securities laws. Securities laws regulate a lot of different things. They regulate how you sell the securities, how much money can you raise, how you target potential investors, the rights of investors to get their money back, and even who you can talk to about the offering. So it's really comprehensive. And we're talking about disclosures and solicitation and things like that. And as I explained, kind of the general rule of securities, the default rule is if you're going to sell securities, you have to register that offer or sale with the SEC. That's like a public offering. That's expensive. Not small businesses, new businesses like a brewery aren't doing that. So the alternative is to identify one of several available exemptions from registration that allows that offer or sale to be conducted without registration. As I said, registration is time consuming. It's expensive. It can be six figures to do an IPO. And it's complicated, and there's ongoing reporting requirements, and so small businesses just aren't able to follow those, and so that's why we have private offerings and with exempt offerings. Now, one thing is when you're doing a securities offering, it's not just federal law you have to be concerned with all the time. In some cases, you also have to look at state laws, which are called blue sky laws, where the investors are located, and verify that you're doing everything to meet with, if there's any applicable state exemption, that you're doing the things that are required by state law in order to meet that exemption, so that you don't run afoul of state laws either. Because one of the issues here and why you need to comply is engaging in a sale of securities without registration can subject the issuer and its officers to civil, administrative, and in some cases criminal penalties. So this is serious stuff. You want to make sure that you are dotting the I's and crossing the T's when it comes to how you're raising money from investors in these offerings. Key concept before I get into the meat of everything is the accredited investor. And I couldn't think of any better way to depict an accredited investor than the Monopoly Man. An accredited investor is a defined term in the law. It means it basically is kind of the threshold for how much disclosure that an issuer has to make to investors. And it comes down to, basically, they assume that if you have a lot of money at certain amounts, you are deemed to be able to fend for yourself, that you're going to have your team of advisors that are going to review the terms of the offering with you and explain them to you. And it takes some of the pressure off of the issuer in terms of how detailed they have to be in their disclosures. What an accredited investor is somebody who has $1 million net worth, not including their primary residence, or if they're an individual with annual income of $200,000 a year, or a couple with $300,000 of income per year, with the expectation that recurs. That's the meat of what an accredited investor is. There's other parts of the definition as well, but that's probably 60, 70, 80% of those that are accredited investors fall into those categories. So when we talk about an exempt offering or an exemption, you hear the term private placement, or a document called a private placement memorandum. And this goes back to Section 4.2 of the Securities Act of 1933. and it exempts transactions by an issuer not involving any public offering. And the SEC has set out safe harbor rules that an issuer follows to ensure compliance with Section 4.2. And when I say safe harbor, it means that just that you follow these. The SEC never signs off saying your exempt offering is copacetic. They provide a way of safe harbor rules that you follow in order to argue that to rely upon to say that your offering is exempt. So you don't get the checkbox saying you're okay, you can proceed. So with the most common one historically has been what we call Regulation D. That's the set of safe harbor rules that issuers follow to ensure they're conducting a valid private placement. Historically there was Rule 504, Rule 505, and Rule 506. Today, we have Rule 504, Rule 506B, and Rule 506C. And I'm going to walk you through a little bit of the history. And I think, just a little side note, the growth of the craft brewery movement, in the early, mid 2000s, I think fueled the reforms that come about in 2012. That we'll get to in a little while later. But I had brewery clients that had a hard time raising money from the traditional investor sources, and bumping up against some of the restrictions of Regulation D, which then led to Congress enacting what they call the Jobs Act, and more on that later, to make it a little bit easier for businesses like breweries to raise funds. So this is today historically the differences between Rule 504 and 506. 504, you could raise up to $10 million. It used to be $1 million. Later it was $5 million. Today it's $10 million. Rule 506, it's unlimited amount. There is no advertising under either of these exemptions. With Rule 504, it can, if it's coupled with a state exemption or registration that does allow advertising. Most common being the small corporate offering registration. You can use that at the state level and be able to advertise. At Rule 504, you can sell to anyone, but you do have to be aware of the state restrictions as to how many non-accredited investors you can have. Usually it's somewhere in the range of 25 to 35. Rule 506, it's an unlimited number of accredited investors, and you can sell up to 35 non-accredited investors if you believe they are sophisticated. There are, in terms of disclosure requirements, for 504, we usually do a private placement memorandum. There's a lot more detailed information provided. With a 506, if it's accredited investors only, we usually provide their subscription agreement, some corporate documents, a business plan, and if there are financials, we do them, but there's not required. If under a 506 offering, if somebody is selling to non-accredited investors, there is a requirement that audited financial statements have to be provided. So with a 506, if you're raising money for your brewery, you're not likely to be using 506 if you're going to go to non-accredited investors, because to pay for audited financials for a business that isn't even operating and generating revenue yet doesn't make a lot of sense financially. And so most of the time we use 504 because at least at the initial stage, $10 million gives us plenty to work with. And a lot of times when we're doing an offering, we're looking to maybe raise to take in money, to raise enough money to bring to the table to ultimately do some kind of a SBA loan or something like that with a bank. Verification that an investor is truly accredited, with either of these exemptions, the issuer, the business, doesn't have to do any kind of due diligence to verify their accredited status. The accredited investors can self-certify. If any of you have ever seen a subscription agreement, there is a section where the investor, because they ultimately sign the subscription agreement and they give it to the business with their check, or they wire the funds in depending on the amount. And there's a section where the investor has to initial as to how they are accredited. That's self-certification for either of a Rule 504 or what's now 506B. Investors are able to self-certify. The significance of that is if the investor says they're accredited, but they ultimately turn out not to be, that doesn't come back on the issuer for doing an offering for missing the exemption, being outside of that safe harbor, because they were allowed to rely on that investor's representation. So that's the significance of having the investors being able to self-certify. With either of these two exemptions, there's no general solicitation. What that means is it's friends and family only, no social media, no TV, radio, newspaper, no prospective investor events. So, but let me be clear about what that means. And I've been at investor presentations for some of my brewery clients over the years, and it's a great, if you can do this kind of event, it's great, because if you've got samples of the product, things like that, it helps the investors maybe want to make a decision and invest. You can have that kind of event as long as you didn't advertise to the public that you were having the event. If you want to bring in friends and family, existing business and personal connections, and put them in a room and hand out samples, and as you do the business pitch, that's not a problem. Just be careful with how much alcohol you're giving them. I had one client one time that had a unique homebrewed beer that was a really high alcohol content, and I told them, let's wait till after the investors write the checks before you serve that one, because I think you start to call into question after the end of the night, if you lead up to that, whether or not somebody has the capacity to even write the check. Don't go there. So save that one. So you can do an event with people that you just can't advertise an event like that, like an open to the public type thing, under either of these exemptions. So as I mentioned before, we went with almost 80 years with Regulation D being the primary safe harbors, and Rule 504 and ultimately 506 as the two buckets to drop into in terms of exemptions. It was difficult. I had some clients that they just didn't have the friends and family with a lot of finance, a lot of capital, able to invest in the brewery. So it took some of these longer than others to try to raise funds, and it gets frustrating. I had a couple that went 12, 18 months still trying to raise funds for to get their brewery launched. And so in 2012, we have the Jobs Act of 2012, the Jumpstart Our Business Startups Act. Nothing leads to bipartisan reforms like an election year. And here you had both parties in power in different places, and they agreed that it was time to do something to streamline and reform federal securities law. And we come up with the Jobs Act. Now, what the Jobs Act does, it's three key components. We have what we call Title II, advertising, now allowing advertising in connection with sales to accredited investors. This is the new 506C, became effective in October 2013. This one continues to grow in popularity. We have Title III, which is called crowdfunding for all. This is Regulation CF now, and this one, they released proposed rules in October 2013. Every one of us that were handling securities transactions hated them. They were way overcomplicated, and it basically defeated the purpose of having equity crowdfunding. And so they went back to the drawing board, and they later come out with, I think it was 2016, they came out with the final rules. And I understand, you remember I talked about the reason why we have securities laws. was you had in the stock market crash, you had a lot of people that didn't have a lot of means that lost everything. So this was, I think, really philosophically difficult for the SEC to put forward these rules, because they're cognizant of their mission in the first place, and historically why they exist. And so ultimately we get to the rules, but in the meantime we also have state crowdfunding laws. I'll talk about that in a minute. They still have some applicability, it's just a little bit more limited. And then finally we have Title IV, which is the Reg A plus mini IPOs. Became effective in June 2015. You can raise up to upwards of $50 million with this type of offering. I'm not going to cover it as part of our presentation because they're just really now becoming more popular, and it's definitely not breweries that are taking advantage of Reg A plus. It's usually going to be Reg CF or still one of the Reg Ds. So just kind of a comparison under the new 506C. It's all the same. You can still unlimited amount. You can advertise. That's different from the old 506, which is now 506B. You can sell only to accredited investors. You can't sell to non-accredited investors. That's why they have regulation CF. No need to provide any sort of financial statements. I can tell you from a practical standpoint, I think investors question if you don't have something in terms of at least financial projections. So you aren't legally required to do it as part of the safe harbor, but from a practical standpoint, it's a good idea. And here's another big thing. The trade-off for being able to advertise. Before, you were only soliciting people that you knew, friends and family, and they were allowed to self-certify. Under 506C, the trade-off for allowing the advertising to a broader segment of the population is the issuer has to take reasonable steps to verify that the investors are in fact accredited. Now, that can be reviewing tax returns, financial statements, getting a opinion letter from their attorney or financial advisor, somebody that knows what somebody's financial situation is and is able to attest to it. There are verification companies that sprung up in the wake of this legislation that an issuer can pay an amount per verification, and they're usually tied to a broker dealer outfit, and those verification companies will actually do the verification for the issuer to undertake to do the due diligence. If you're trying to start a brewery, the last thing you want to be doing is pouring through somebody's tax returns to verify that they're rich enough to invest in your brewery. So if you're going to do that type of offering, you can use a verification company to do that, and they're not too bad. I remember having a client engage a verification company, and I think it was $5 or $10 per verification. Now, they're doing a lot of them for the person, so it makes sense for the verification company, but it was pretty reasonable. There is still intra-state crowdfunding. Some states have it, some don't. Where I'm sitting here in Minnesota, we have something called Minvest. This was a response from the states in frustration to the SEC's kind of dragging their feet on coming up with their own equity crowdfunding regulations. And so interstate offerings are exempt from registration under federal law. So if you are in one of those states where you have an intrastate crowdfunding law, and if you've got, and you look at where the investors are. So if you've got a state where all the investors, I did a few of these here in Minnesota where breweries located in Minnesota, all the investors are Minnesota residents. So we could use our Minvest equity crowdfunding statute at that time to raise the funds. Those have kind of become antiquated. So I'm going to kind of skip over this a little bit. They're become antiquated in the wake of the regulation CF. So here's the A plus. I'm going to skip this. You can do it. You said there's 20 million under tier 1, 50 million under tier 2, but this really is I'm dealing with a company that's doing like a coin offering, that's doing something like that's raising these kinds of funds. You wouldn't need this for a startup brewery to do a mini IPO. The cost would far outweigh the benefit of doing that. So we get into Regulation CF. That's the federal equity crowdfunding exemption. It went into effect May 16th, 2016. It's Section 4A6 of the Securities Act of 1933. Initially, what it said was you could raise up to $1,070,000 in a 12-month period. The offering had to be done through a SEC registered intermediary, either a broker dealer or an internet-based crowdfunding platform, a funding portal. And there's a lot of these out there. There's Crowdfund, WeFunder, Silicon Prairie. There's a lot of different organizations, a lot of different platforms out there that will sponsor a crowdfunding offering. If the annual net income or net worth of the investor is less than $100,000, the investor is limited to the greater of $2,000 or 5% of the lesser of his or her annual income or net worth. If the income and net worth is greater than that, then they can go up to 10%. So there are guardrails, like I spoke of earlier with Regulation CF, so that investors can't invest too much, as deemed what too much is defined by the SEC. So there has since been amendments to Regulation CF. The 12-month limit is now up to $5 million. Once Reg CF went to $5 million, any state-based crowdfunding exemption was usually at $1 or $2 million. So they pretty much became worthless to a lot of businesses. They wanted to focus on the $5 million maximum with Regulation CF. There are, however, tiers to what you can rate, what you have to provide when you do a Regulation CF. There is an SEC prescribed disclosure document called Form C, and a lot of the information that they put into it. You're going to have a business summary. Some people put in their full business plan. Others, it could just be a slide deck, like their pitch deck, that they would show at an investor presentation, but it just has to be a summary of the business and what it's doing. You have information on management, so officers and directors for a corporation, managers for an LLC, information on anybody that owns, say, 20% or more of the company, terms of use, or terms of the offering, in terms of minimum, maximum, price per unit, price per share. If it's notes, it's just going to be face value. What the security is that's being sold. That all would be in the terms of the offering. Use of funds, the breakdown of how the business is going to use the funds. So for a brewery, it could be maybe using some for, say, year one of lease payments while you're waiting for your TTB approval. Could be paying some deferred comp, or paying some compensating salaries to the principal employees of the business. Could be equipment purchase. All those different things could be, use of some part of the use of funds for the offering proceeds. You'll have material documents. So a lot of times it's the articles and either the operating agreement for an LLC or a shareholder agreement for a corporation, bylaws, things like that. If you're doing an offering of promissory notes, like a convertible note, you would include a form of the note as part of the material documents. If you're doing a safe, simple agreement for future equity, that a form of the safe would be included. So all those material documents, you'd want to include a capitalization table. So what is the ownership of the business as of the date of the offering, and then financials. And this is what this slide is about. Depending on how much you want to raise, if you go less than or up to 124,000, you can use internal self-certified financials. So your P&Ls from QuickBooks, that type of document. The CFO signs off attesting to the fact that they're accurate and complete, and you can include that in the Form C filing. If you want to raise more than 124,000, up to 618,000, you have to have your financials independently reviewed by a CPA. If you want to do more than 618,000 up to the 5 million, then you have to have the financials audited by a CPA. However, if you are a first-time issuer, you can do 1.235 million with reviewed financials only. Accredited investors are exempted from investor limits. A lot of times, what we do with these days now with the changes is, though we don't necessarily use a lot of put the accredited investors into the Reg CF offering, because you can do what we call a Reg CF plus D. Remember that you can raise more up to an unlimited amount with Reg CF under 506C without having to provide the financials. So I have a lot of clients that will do a raise of they'll cap the CF offering at 124,000. That way they can use their own internal financials. And then if they want to raise more than that, then they do a Reg D offering, a 506C, to accredited investors only. Leave the non-accredited investors in the CF and the accrediteds in the D. You can do that. It all depends on what you're trying to raise. If you only need, say, 450,000, maybe you'd go ahead and take the time to do the reviewed financials and not bother with doing two separate offerings and two separate offering documents. So it just all depends on the facts and circumstances as to what stage are you? Is it a startup? Is it kind of going to the next level? Maybe expanding and putting in a canning line or buying more equipment, relocating into a larger facility and then needing to purchase more equipment. It all just depends on what the nature of the need is as to why you're going out to investors to get capital, in terms of how we structure this, if we're going to rely on CF or if we're going to do something under Reg D. The Form C is the offering prospectus. It's filed with the SEC prior to the portal site going live. As I indicated before, it's detailed information it's like a business summary, the entity structure, terms of the offering, management, capitalization, use of proceeds, risk factors. You'll have a set of risk factors. We kind of have a boilerplate. I have a boilerplate, at least for a craft beverage business, as to everything from, it's a brand new business, we may need more money, regulatory environment can change, all those types of things. It's a consumer, it's driven by consumer taste, and consumer taste is fickle. All those are examples of risk factors. That's all in your Form C. The financial statements as required. If you're planning to use a video on your portal site, and some people do, you have to include the script with the Form C. And it gets filed with the SEC online via EDGAR. The SEC doesn't look at it, so there's no kind of merit review. It's just you get a notice that it's been accepted once you've filed it, properly, and then you're off to market. Your intermediary can flip the light on your portal site, and you can start raising funds. In terms of the comparison of the fundraising models, a Rule 504 plus a state exemption, it's 10 million, no advertising, yes, non-accredited investors, no detailed prospectus. If you do a 504 with a state registration, like the score that I mentioned before, again, $10 million, you can advertise, you can solicit non-accredited investors, but you would have the detailed prospectus. I haven't done a score offering in a while. I think they've revised it, but it used to be about a 70 question document that the issuer would have to fill out, and that becomes the document that you file with the state as your registration. The Reg CF, the Form C, is a lot less complicated than the old score offering statement. Under 506, first 506B, well, either 506B or 506C, unlimited amount of funds that could be raised. 506B, no advertising. 506C allows for the advertising to people other than friends and family. Under 506B, you're allowed to go up to 35 non-accredited investors. 506C, only accredited investors. In terms of how the detailed information, if under 506B, if you're going to solicit non-accredited, you have to have a detailed prospectus. Not the case for 506C. Reg A plus, like I said, you can have advertising non-accredited investors. You do have to have a rather detailed prospectus. It's much more complicated than anything under Reg CF. And then finally, Reg CF up to 5 million. You can advertise. You can have non-accredited investors, and it is the Form C is a pretty detailed prospectus. So that's kind of the range of options in terms of the various exemptions that are available as of today. So that's one piece of this. That is what do you do to comply with federal and state securities laws, and that is a big piece of it. But the other piece in terms of an offering of securities is more of the practical. Is first of all, what do you want to sell? If it's equity, what percentage of ownership you're going to sell? Are the investors going to have voting rights? Are they only going to have financial rights, meaning profits? If you're going to do non-voting equity, you usually have to come up with some sort of trade-off to that. So you're usually talking about either a preferred distribution or a distribution preference. A preferred distribution would be, for example, a cumulative annual preferred return of, say, 7%. So you'd have something, let's say you're an LLC, you put something in your operating agreement, you say you have your Class A members, which is the founders, Class B members being the investors. Class B members have the right to a 7% annual return. And if the company doesn't have the funds to pay, it rolls over, accumulates into the next year. It's seemingly a little bit like an interest payment, but it's a way of guaranteeing that investors get something for their investment until the point where the company is declaring larger distributions to everyone. That's a preferred distribution. This is why you want to be clear in terms of your use of funds, whatever exemption you use. Because if you have to structure your offering to pay out some amount back to your investors in year 1 or year 2, you want to make sure that the founders are making sure they're getting some sort of salary or something, because they may be waiting on profits distributions for several years. There's got to be some reason for doing it. So you want to make sure that that you have some sort of line item for their salaries too, or a guaranteed payment, some whatever you want to call it. A distribution preference, in contrast to a preferred distribution, is sort of a skewed way of handling distribution. So you might have let's say that you've got the founders own 60% of the company while the investors own 40%. A distribution preference may say that the 40% of the investors, the Class B we'll call them, will get 60% of the distributions until such time as they receive distributions equal to their original investment amount. I've structured offerings like that before. So it all just kind of depends. Now, this is all dealing with selling equity, stock, or membership interest. There's other things you can do. You can do a convertible note, which is a debt instrument that converts at certain triggers. So if there's a later financing event, it may trigger the holders of the notes would be converted into shares or units of that equity being offered. It could trigger on the sale of the company or an IPO, or then you have to decide, or you can have an option that somebody has the right to convert all the way up to the maturity date. There'll be an interest payment. There's usually a maturity date of 4 to 5 years, and at maturity, it gives the business, the issuer, the option of either paying it back or converting it. I've structured those like that. So that's convertible debt. There's another thing on the market called a SAFE, Simple Agreement for Future Equity. It's similar in some ways. It's like a convertible note, but there's no maturity date. It's just triggers for when the SAFE might convert to equity. I haven't had a brewery use a SAFE. I've seen them use convertible notes, and I've seen them use just straight equity. But I haven't seen a lot of beverage businesses do anything involving a safe. It's usually for kind of the high tech stuff, and they're you still have a lot of kind of resistance to them unless somebody understands what they are. So back to the scenario: if you're selling equity, if you're giving these special rights to investors, say a preferred distribution or a distribution preference, at some point you want to be able to cut it off. Meaning, and we use that, and we use call rights and put rights in that context to sunset these preferences. And let's say for an LLC with an operating agreement, a call right is the company's right to call the owner those shares or units in, and under agreed upon terms. There'll be a valuation and a structure of a payment over a period of time to retire those units or shares. Put rights is the opposite. Puts the power in the hands of the investor, and they have the right to put their shares or units to the company. Basically, require the company to buy back their interest. You have to be careful with how you structure them. Obviously, for an issuer, call rights are much more favorable than a put right that would then have to have you run out and maybe get additional investors or go borrow funds if you don't have the funds available to buy out investors. I have some breweries now that have been around for a decade or so, and they're starting to take steps to retire their original investors so that the founders can recognize more of the profits from what they've been building. So again, that's just another piece of this, is to be able to put these offerings together. I've left quite a bit of time, I think, for questions, but I don't know if we have any questions. But I can kind of go through and kind of talk about a few other things about this. Just some general rules about. And I'm going to escape out of the slideshow here and go back to, and I'm going to stop sharing the screen so everybody can see me. So a couple of other things to think about, specifically related to a business that, like a brewery or any kind of a craft beverage business. Always have to remember 3-tier rules. You can't, if you've got a bar owner, a lot of state laws will say they can't own an interest in a brewery. Depending on where the state is, there may be some loopholes around that. Here in Minnesota, our alcohol and gambling enforcement will say that the spouse is an independent person, and so we have a lot of situations where the spouse owns an interest in the brewery while the other spouse owns the interest in the bar with the retail license. So just be cognizant of that. So we have one question here. So have you seen investors be offered seats on a board of directors rather than explicit voting rights or distributions? I don't know if I've seen it as an either or, but I have seen some offerings where depending on the size of the investor, where seats on the board are part of. If you invest X amount, you might get a seat on the board of directors. Yes. And that's a good question. It leads me to another thought here too. Once you come up with the terms of offering, and whether it be a CF and you're filing your Form C prior to starting your offering, or with Regulation D, there is a SEC filing requirement. It's pretty minimal. It's called a Form D. And it gets filed 15 days after the first sale of securities under the offering. So once you go to market with that offering, you've really locked in your terms. And you want to always be careful. You get that investor that takes the private placement memorandum or whatever the offering document is as the opening offer in a negotiation. It's not like that. and it creates complications. If you say, let's say you're doing an offering of $500,000 and you've raised $50,000 so far, and somebody wants to come in and put in, say, another 50, but different they want other things that are not called for in the offering document. Here's the problem with that. If you decide to make changes to accommodate that new $50,000 investor, you have to go back and notify all of your investors up to that point of the change in the terms, and they have the right either to stay in under those terms or to rescind their investment and get refunded their money. Okay, so my rule of thumb, what I tell my clients is, unless the investor coming in that wants big changes is going to write a check for at least, at least the minimum amount that you need, don't, and you've got other investors already, don't go changing the terms of the offering. For the Reg CF, it's particularly problematic because it adds additional administrative expense. Because anytime I have a client that wants to change the terms of their offering or change anything about whatever is in that Form C that we filed with the SEC, I need to go in and file what they call a Form CA, which is an amendment, and amend the original offering document, which of course takes time and costs money. So we have to go back and adjust that. I've had some that I had clients that thought there was a good offering. They went to market. They were just flat out told by investors, we don't like this. We want you to do something different. So we did, in that case, have to blow it up and redo it. And fortunately, they did sell out their offering. But be aware of that when, a lot of times it doesn't always necessarily be a board seat. Sometimes I've seen it in the context of, say, like an LLC with an operating agreement with wanting certain rights, like veto rights over certain transactions, like sale of the business or a merger or leasing new space or something like that. So just be aware that when you get the investor that wants to negotiate, they better have a big enough check to in case you have to kick other investors to the curb or start over. How are decisions made if investors do have voting rights? Another good question. And you have to think about when you're doing any type of an offering. Let's say you're at the startup level. You want to make sure, as the founders, that they stay in control. And so you want to be you don't want to sell more than 50% to investors, and that might not be just in round one. It could be you may contemplate multiple rounds of financing. So what I would say, and this is what the importance is of the business plan, is know what the later phases of the brewery are. Are you going to start out with, say, tap room only, distribution only, have the bottle shop, or you sell crowlers and growlers on site for off-premise consumption, no distribution beyond that, and that's fine. And maybe you're just raising enough to get that piece open. But maybe you ultimately contemplate having a larger space and more capacity and a canning line. Think about those things and what those phases are, because you want to make sure that you don't sell so much in your first round that if you have to do round two or round three, that you have to go back and you have to give up more than control. Now you've got the investors in control. And I've had that situation too, where I've been representing the investor, and it's not fun for the founders to be kind of shown the door once they've got everything set up and running. So just, be careful about that. So I got another question here. So do you represent to investors that they have a percentage ownership, or just a specific value that could then ultimately be a smaller percentage of ownership? Okay. So if you're doing an offering and you're selling 20% of the company, you'll say, we're selling, could be shares or units. We're selling, X number of shares, X number of units constituting 20% of the company. one of the things you're going to want to disclose as a risk factor is the risk of dilution. Dilution is the risk that somebody's, maybe they initially buy in at a 5% ownership. If you disclose that you may need additional funds in the future to carry out your full business plan, and if that's the case, their 5% may ultimately become 3.5%, depending on how much more you have to go out and if you're offering additional, shares of equity. They may be diluted. So you want to disclose that, because their percentage ownership may decrease over time. I didn't say this before, and I should say it now. When I talk about the safe harbors, there's two ways to get into trouble doing a securities offering. One is to do it without registration and without an exemption from registration, and you avoid that by just following the safe harbor rules, working with somebody to make sure that you do everything that's to be legally compliant. The other piece, which you can never ever escape liability for completely, is liability for securities fraud. The only thing you could do is to mitigate the risk of being of a fraud claim is to disclose. So you disclose anything that might be relevant to the investment in that offering document. Whether you get into I have clients that they'll read my documents and they'll see the risk factors and they're like, oh boy, that makes it sound like a really unattractive investment. I'm like, that's the point. You're basically saying buyer beware, and if you don't have, if you aren't comfortable with these risks, then don't then don't invest. And in case if somebody does invest after you've disclosed all the applicable risks, then they can't be said to to be defrauded because they knew going into it. Another question: what if you decide to close the business? How does that work with SEC regulations? There really isn't for an exempt offering such as this. There isn't ongoing reporting requirements with the SEC. I think for the Reg CF, there's one annual report that you have to file, and then if you're at that point, you're able to get out of filing additional reports. So there's really nothing ongoing from a reporting standpoint where you would have to give notice to the SEC that the business is closing. So no issues with that. With public companies, obviously, there's ongoing quarterly and annual reporting requirements. Same thing with the Reg A+, but we're not talking about doing IPOs or mini IPOs. But for CF and D, there wouldn't be anything that you'd have to do. Now, again, we get into the issue of what you have to manage investor expectations. If you close, obviously, the investors may have a say in that if they have voting rights. If you're dissolving the business, and so you just want to be transparent with your investors. And if they are equity investors, you want to be fully transparent with that. If you're doing, say, convertible debt offering, and you close the business, you might have an issue. You have to deal with the fact that you have creditors in terms of the note holders, but nothing with SEC. So. So we got a few minutes left. I'm trying to think if there's anything else that, one thing I would say is if you're looking at this and you're seeing the numbers that I quote in the slide deck, be aware that the SEC does change those limits from time to time. During the pandemic, they had gone up to 250,000 and $1 million. Instead of 120, it was 250,000 up to that with self-certified financials, and $1 million and over would have to have audited. Anything between was just reviewed. They dropped those back down at some last year, but then they adjusted for inflation. to where we are now. So we still are dealing with inflation. So there could be another inflationary adjustment later this year or next year if the SEC deems it necessary in order to keep pace with to keep those limits at a certain amount. Could investors hold the bag for outstanding debt if closing or bankruptcy? Not if they didn't personally guarantee anything. And I've had offerings like that where somebody was maybe given an addition where, this was the offering was being done to raise money. It was going to be like, say, the part of the 20% down to get the SBA financing. And say none of the founders had a financial standing where their guarantee was of value to the bank. So the bank was looking for some other guarantor. And I had one client that actually gave an extra 5% to the investor that was willing to step up and be the guarantor. In that case, that investor would have been personally responsible for any debts if the business closed, but thankfully the business is alive and well and thriving. So no issue there. So only if the investor was a guarantor would they end up maybe possibly being responsible for the debt. What more happens if they're closing or filing bankruptcy is the investor is out their investment. Because even if they're just at a lower priority over, say, a secured creditor. If there was a bank involved and there was a lender, they're going to be the priority secured creditor in a bankruptcy, and the investors are just going to be out. That's part of why we have securities regulation and why we have different rules for depending on different income limits, because it's the state and federal securities folks trying to come up with safety nets for investors depending upon their level of income. Basically, making sure that you don't. Again, the whole point of securities law really is to avoid another 1929, and we have had stock market crashes over the years: 1987, 2008, 2020 during the pandemic. But they were nothing compared to 1929. And so the securities regulators are cognizant of the history and why they exist as regulators, and when they're making up different rules. So, do we have any more questions? I think we got another minute or so here left in my time here, but do we? So I think we're good. So I think in the slide I put my contact. If anybody has any questions, please feel free to reach out. If you're a brewery that's getting started, be sure to be working with an attorney when it comes to this piece, this compliance. I mean, you're probably already working with an attorney anyways, but make sure that you have somebody that knows the ins and outs of federal and state securities laws. If you don't know what you're doing, it can be a recipe for trouble. So I want to thank everybody for being here today. And if you have any questions, reach out.